Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. I think you'll find this week's discussion relevant. I'm willing to bet that the vast majority of you will. We want to talk this week about, it ties in with estate planning, and I know estate planning is potentially can be boring. I know that, even to people who do it.
Is that right, Jim?
I'll admit it.
But there are aspects, though, that are fascinating to me as an individual, as a business person, as a parent. And that's when I think about, well, how do I come up with an estate plan that's going to take care of my loved ones best, my wife, but especially my children and their children, and maybe even their children. But we don't have to go that far down the future family tree to realize, how important it is and how we should be interested in talking about, is there a way that we can make our estate much more beneficial to our children than to simply hand it to them? And we've talked quite a bit over the years on this show about the fact that I certainly believe, and many experts believe, that it's just a mistake to simply hand money to your kids. Even to simply say at some age, oh, they're 30, so now I'm going to hand them whatever it is. I'm not just assuming that I'm talking to people who have millions of dollars to give. I'm talking to people, many of whom, maybe it's $100,000 that you give to a child at age 30. Maybe it's $300, maybe it's $400 or $500. Many of you it'll be more we're talking about. And I'm saying for the most part, it's often a mistake to do that for various reasons. We'll get into that in a second. But to help us through this discussion, we have an authority on this topic. So
Yes,
Jim Gau, our regular go-to person to talk to about estate planning. So I think that I would say, if I were giving a title to this discussion, which as a matter of habit we should probably do, we should probably come up with titles for these shows, for each particular show. But in terms of a topic, though, what we've dedicated this show to is to discuss ways that you can better plan for your kids and their kids to give them the most bang for the buck that you're going to be leaving them. So, Jim, I'll toss it to you. Should we do any further introduction of Jim?
I think we all know Jim.
I'm a regular now, I think.
He's our legal analyst. Yes.
Yeah. It's hard to get people to appear on here free, so Jim's available.
Wait, you aren't paying me?
I might say he's captive. So anyway, Jim, give us your thoughts.
Yeah, so I mean, obviously estate planning, when someone comes into the office, they're talking about, where is my stuff going to go? And we always start by going through, generic family information, name, rank, file, serial number, and then, who are your kids? How old are they? Do any of them have any disabilities? Grandkids, do the grandkids have disabilities? Are any of them bad with money? Are we afraid one of them's going to get a check and run to Vegas and put it on red?
All different types of
one of those.
personalities you have to consider, to tailor your estate.
Yep.
Really, and as a mom myself now, I think about that. And I know I just don't want to hand over money to my kids.
Yeah, and even if your kids, though, are, perfectly well balanced, their judgment is wonderful, they're emotionally strong, and they're mature, all those things, there's still a lot of reasons to not do it.
Absolutely. And even if your kids are great and your grandkids are great, well, you've got in-laws.
Exactly.
So they're going to step up and at some point, and even if they're not named in your estate plan, which normally they're not, it's usually descendants, blood relatives, but even if they're not named in your estate plan specifically to inherit anything, they have a pretty big influence over your kids, considering they're married to them.
And we could have lawyers from Cordell and Cordell come and talk about, give nightmare scenarios that they're not fantastic at all, meaning they happen every day, where, as a matter of fact, it's almost routine. They have a divorce in which one of the parties have inherited some significant or substantial amount of money. It could be $50,000, could be $1 million or more. But I can tell you that even if it's $50,000, it's a big deal to that wife, for example,
Sure.
who it was the only thing her parents had to give her, her share, and to think that because she didn't know how to handle it with punctilious care, that she ends up allowing it to become a marital asset, and it ends up half of it going to her soon-to-be ex-husband. And it's just very difficult to manage that money in a correct way to protect it. And it's very unusual to have somebody who does do it. So it's safe for you to assume that if it's possible or probable that a divorce will occur, then you have to realize that whatever you leave could be cut in half going to the other party.
Yeah.
Right. Yeah. And when I tell clients in meetings, I say, if we set this money up, if we give it to them outright, I know 90% of the time they're going to take the check that they inherited for the money and they're going to run and put it in their joint bank account. They're just going to put it right in their marital bank account, not think anything of it. 5 years are going to go down the line, and there's just no way to trace that money back to the inheritance.
Right.
And some of them mistakenly believe, and I understand how this can happen. They think, and these are the ones who are more analytical about it. They say, I think I won't put it in a joint account because that could make it a marital asset. So I'm going to put an account in my name only. Now it's safe. Well, almost without exception, those accounts contain monies that are marital. If you have in that account your paycheck, for example, which is most likely what's going into that separate account if you have one, or you choose the example, the probability is the money that's in there is marital. So now you've tossed it in an account that, albeit it's in your name only, but it's just as marital as those accounts that are in both names.
Yeah, and so I actually advise, I tell the clients, if we set these lifetime trusts up for your children, they almost have a built-in excuse not to put it into the joint marital account. And so even if they wanted to, the trust is there. It has its own tax ID number. It has its own accounts in the trust name. They can tell their husband or wife, sorry, honey, this is my inheritance is in a trust. I just can't take it out and put it in our joint account. We can use it, but it's not going in the joint account. So it's almost a built-in excuse.
Right.
Yeah. And talk a little bit about how it can protect people in terms of financial hardships or other things that might happen.
Yeah. So the trust, the lifetime trust accounts, and tell me if this is where you're going with this question, are separate from your personal assets. So if there's someone that is collecting government benefits, for example, or is on disability, Medicaid, that money is not theirs. It's a discretionary ability of the trustee to use it on them. And so that discretionary ability to distribute the trustee's hand can't be forced to pay for things like nursing home care. In fact, there was a ruling just recently in Minnesota where they affirmed it, saying that irrevocable trust assets and trust assets outside of a beneficiary's name are not countable for Medicaid. So yeah, needs-based benefits, these trust assets will definitely help children if they're collecting those.
And this is the perfect scenario because it allows you to leave assets to your children that will not be counted when you don't want it to be counted.
Right. It'll protect them.
It protects them. And not to mention that, back to the assumption that your children have wonderful judgment. Even kids with wonderful judgment can have business failures. They can have a bankruptcy. I mean, that doesn't just happen to reckless and irresponsible children. That can happen to children who were exercising the best judgment they could. Recession comes along, and suddenly they're wiped out. Well, normally any assets that they've accumulated would be on the table to creditors, to collectors, to bankruptcy courts, et cetera. But guess what? Those assets that are in this trust that we're talking about, those are not available. And those assets are protected from even creditors, legitimate creditors of your children, because they were placed in a trust that you created that protected them for generations to come, perhaps.
And building on that, too, that's why, isn't it true, Jim, it's a good idea not to sign your assets over to your child when you're alive. Say your house, because what if that child is subject to a lawsuit? Well, there goes your house.
Yeah. Not to mention you're giving up just complete control at that point. But yeah, you're right. Not only that, but let's take something like a house, an appreciable asset that maybe the family. I had a client this morning. She had her house for 53 years. They bought it for $17,000, and the house next door sold for, I think she said $225 recently. So things like that. If you gift it over to your kids, as of right now, they wouldn't get a step up in basis at death. And so it's a tax problem, too, if you gift your assets over to your kids while you're alive, because they go to sell it and their basis is lower than it should be. Yeah,
and I don't want to get too esoteric on the tax question, but I'm tempted to have you comment on this. By way of a little more explanation, whenever you buy a house, whatever you pay for it pretty much is going to be your basis in the house. So in this example, $17,000 was the basis in the house, and we'll assume it's worth $217,000. So you have $200,000 of appreciation. That would normally be taxable. So historically, when you die, one of the good things, there aren't a lot of good things about death, but one of the good things
about— There are some good things.
Yeah, depending on what life was dealing you at the time. Yeah. But in this case, you have $200,000 that suddenly you get a new, what we call a stepped-up basis. It's a give-me that's historically happened at the time you die. So that means suddenly, from the IRS's perspective, the basis is no longer $17,000; it's $217,000, meaning that the day after you die, assuming that the asset were transferred then to your child, they could go sell that house, and all that would be non-taxable because their basis is $217,000. That was the value at the date of your death. So this has been a huge gimme, but that's about to go away, might it?
Maybe. So that's what's gained the most traction in Biden's kind of new tax plan. But it's getting a decent amount of pushback because things like family farms, that the farmland's been in that, the family for the parents' entire life, and that farmland's appreciated in value. And I think what the plan is to treat it, the Canadians do this, they treat it as a sale at death. And so it triggers that tax automatically. And so now we're worried that family farms are going to become corporate farms because they have to sell parcels off to pay the tax every time somebody dies. And also small family businesses. I mean, think of your local heating and cooling business that was started, 100 years ago maybe, or 50, 60 years ago even, for basically nothing, for the amount that it takes to file an LLC, that's now worth a couple $1 million. So things like that, it's small family businesses and family farms that are really going to get hurt if it just completely goes away. So they're trying to carve out some exceptions.
So now what we're talking about now, the trust that we recommend for the vast majority of our clients are not designed primarily to think about tax issues because we have huge exemptions right now that go up to essentially for a couple close to $22 million. So for the vast majority of Americans, there's not a quote-unquote estate or gift tax that they end up paying with those huge exemptions. But there is concern that would change, in which case, we would change the nature of this trust. But the reason we set up this trust is it's not primarily tax-driven. We designed this trust for the vast majority of people who don't have the levels of assets that they have a problem when they pass away. So we're thinking of the 98% here. And the 98% of you out there, a trust is a marvelous thing for reasons unrelated to taxes. And that's what we want to focus on in this discussion. If the law changes, though, the marvelous thing about trusts is they're incredibly powerful weapons or tools for tax planning. That's the reason the rich use them. So if we redefine the rich to include 50% of you from what now must be no more, at most 2%, that probably are above that 22 million, then yeah, we would also have as a characteristic of this trust some really incredible things to help you save taxes. But right now we're not doing that until we see legislation come through that might change it. And suddenly we'll have a show in which we'll talk about all those marvelous reasons. But that's simply icing on the cake in that case. Because without any consideration of taxes whatsoever, the power of having a trust, the huge benefits to average people, it's a shame that many people go out of this world with a simple will, and which dumps assets for the most part in the laps of their children, their loved ones, or whatever. And they could have done so much more for them, given them something that they can't do themselves. They don't have the ability. Some people think that, oh, well, if my kids want to do that, if my normal, well-adjusted kids, if they say, well, my kids, I don't have to protect them from themselves, they have good judgment. Even if that is your kids, which would be, incidentally, I suggest the substantial minority of you. It's like what was the place from PBS show where all the kids, the town where all the kids were above average? Justin, all right, Lake Wobegon. I'll just tell you while he's looking it up. It just occurred to me. So here the funny thing is that in Lake Wobegon, he says, in introducing it every week, he would say, and where a town where all the children are above average, and meaning that, we can't all have kids that meet the criteria of being self-sufficient. And the joke is that many of us think our kids are capable, and the reality is of managing their money, for example, and the reality is they're not. But many of us want to believe that our kids would do just fine. But maybe we're not looking at that as objectively as we could. So, but even if we were, the point is, these children do not have the ability themselves, if they got the money handed to them, say in your will. So they get a $500,000 check, one of your children. That child cannot go to a lawyer and say, okay, I want you to protect this money in a trust from all those things we just talked about, from creditors, bankruptcy, divorce, all those things. I want you to protect this asset for me. You can't do it. There's all sorts of limitations to what's called a self-settled trust. Yeah. And they can't give that gift to themselves. And that's something to emphasize is many people think, oh, well, if they want to do that with their assets, they can do it. But they can't. Do you want to elaborate on that?
And why, if you think about it, why wouldn't you do it for them? You're already setting up your estate plan. Why give them money and then say, by the way, we kind of think you're gonna spend another $5,000 to set this irrevocable trust up for yourself. But testamentary trusts are a trust set up for you by someone that has deceased. That has died is much more powerful than a self-settled trust every day of the week, and it has been throughout time. If someone else sets up a trust for you, it is much more powerful than setting up a trust for yourself.
And talk about how important it is to do that, especially if you have a disabled child, a child that maybe is mentally challenged.
That's a good point. Yeah. I'm glad you raised that.
Yeah. So disabled children, obviously, it's one of the first questions we ask. After getting their name and birthday, essentially, is do you worry about any of your kids having a disability? And if they do, there's multiple things you can do. So the first thing is in your revocable trust, your standard estate planning document, you set it up so that they have a care manager, someone that can manage the money for them, that can also manage their care, and you set it up in a way that the assets they're inheriting are not considered an available resource to them. And that is for Medicaid, needs-based benefits.
All sorts of government benefits. Yeah. You want them to qualify for all these benefits that are out there. There's state benefits. There's local benefits in some areas. There are federal. And if we word this trust correctly, they will still meet the criteria for those. I mean, from their definitions, they'll be broke, essentially.
Right, right. Yeah, and touching on something you said earlier, even if it's not a disabled child, these trusts are set up in a way and they're designed in a way where you can go to apply for a loan and say, you go ahead and consider I have this trust here, just so we know I have available funds to pay this loan back. Or if you're applying for needs-based benefits, you can say, absolutely not. I have no money in my name. I'm broke. So it's really, 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 convenient for your beneficiaries to have this kind of.
Well, yeah, and especially if that child, say, is mentally disabled and does have to go into some sort of facility after you're gone for their care.
Right. Yeah, those are becoming more and more prevalent nowadays. They've built a few here in St. Louis. I know there's one across the river in Illinois that it's basically a community for disabled adults that have been, disabled. They're 20-somethings, 30-somethings, but mentally they're 14, 15 years old.
And this is subsidized.
Yeah.
Through the federal or state government.
Yeah. Yep.
In order, though, to qualify for this without paying for it out of your own pocket, then you have to show that you don't have the ability, don't have the assets, to qualify.
Right.
So that's one of the key advantages of trust planning. It's one of those just incredibly marvelous tools that is effective in so many ways that no matter, even if you're not somebody who has much money, a trust is a wonderful thing to have, and it's a shame that if you do estate planning that you think, oh, I don't have much money, so all I should have is a will. And I guess I wouldn't go so far as to say that a trust would be appropriate for everybody, but I'm close to saying that. But I'll grant you that if you have virtually nothing and you are trying to save money and it does cost more to do a trust. Why don't you talk a little bit about the cost of the trust, and when might somebody say, well, a trust is not for me, I should instead, maybe it makes more sense to do a will. Make that case and give somebody an idea what it might cost.
Yeah, so when we come in, you come into our office and we go through your generic information, then we get started getting to your assets. And it really depends on the type of assets. So if there's qualified assets, which are retirement plans mostly, and then there's non-qualified assets, which are cash and personal property, real estate, things like that. So if a person comes in and we go through their assets and they've got, a checking, savings, maybe a small retirement account, and a house and a car, for them it might not be necessary to have a trust.
But depending on the amount.
Right, depending on the value. I mean, if you've got a $2 million home that the kids are then going to sell, absolutely we need a trust. But if we're talking $100,000, $200,000 maybe, that's kind of pushing it, whether or not I'd say a trust. It also depends on how many different ways. If you've got $2 million and you have 15 children, then the math, maybe trying to do that in my head, but it may not end up being worth it for each individual child to have a trust. It may cost more to administer those than they actually are getting per child.
And if you only say have one child and you don't have that many assets, you don't have a big bank account, would it make more sense? Because nobody's really going to contest it, too.
But there's still the issue, though, that let's assume you have one child and you have $400,000. And, this person you describe, except it totals up to around, say, $400,000. I mean, I would argue that in that case, you at least want a testamentary trust. And so you should probably explain how you'd approach it.
So I guess let's define testamentary trust for those of you that don't know what it is. So a testamentary trust is a trust set up in your will. But to get there, you've got to go through the court. So you end up with a trust for your child, but you could have done it outside of court by setting up a revocable trust for yourself, which becomes irrevocable at death. That's the asset protection feature of it. But yeah, if you've got $400,000 for one child, I would absolutely recommend a trust. Now, if we're dividing that same $400,000 4 or 5 ways, maybe we can have a discussion. But
because when you say have a discussion, you're saying maybe somebody would say $80,000 per child is you may want to just hand that over to your child. Some people would say that. Yeah. Okay. Yeah. And it's a discussion.
Yes. Yeah, absolutely. And the discussion goes kind of like this, okay, I know you think your 4 kids you told me they're all, responsible adults. But what happens if they, do get $80,000 dropped in their lap? How are their marriages? How are their kids? Are they super wealthy that they don't necessarily want this even small amount of money included in their taxable estate? Because these irrevocable trusts that go on for generations aren't included in those beneficiaries' taxable estates. And we don't know what the law is going to do.
And,
Right.
and it also would depend on the ages of these kids. For example, sometimes, we'll have people who'll come, not uncommonly, we'll have people who come in whose kids are 50, 55 years old even, and they're married, and they've been married for 30 years. So they're not going to place much stock in our concern about the possibility of divorce. Neither would we, quite frankly.
No.
So you'd kind of take that issue off the table. They're substantially older, the kids are. So maybe they have a history of good judgment. Maybe they're not engaged in any entrepreneurial activities, like, high-risk activities where they might be sued or go bankrupt. So I can see how, and I hope that people watching this can see how it's very individualistic when you talk to a client. Because we can all imagine a scenario where we would say, yeah, maybe just do a will and you don't have any sort of trust kick in. There certainly are those situations. So I don't want to overstate the case, but I do want to be emphatic that for the substantial majority of people, it's just a wonderful, wonderful way to accomplish a whole lot. And so you spend a little more, and I want to talk about that too. So I know you can't mention specific numbers, but give them the range of what sort of trust plan you might run.
Yeah, so for a basic will plan, you're probably looking between $800 to $1,500 probably for a will plan, depending on if you're single, married. And then for a trust, you're probably looking at another $1,000 on top of that, $900 to $1,000 on top of that, which the benefits of having it for that incremental price increase, not to mention just the court costs for probate, the filing fee is half of that additional cost for a trust just to file the will. So it's worth the increase in price.
So many enormous benefits with it. Let's talk about protecting your children from a previous marriage. Say your current spouse doesn't like your children. How do you ensure that spouse doesn't deprive your children of their inheritance?
Yeah, so planning with trust is really, really good for that, because you can say in your trust that my money is available for my surviving spouse for the rest of their life, but then immediately at their death, it only goes to my children. And vice versa. The other side of the marriage can do that as well.
And that's a common approach to this sort of blended family.
Very, very common. And even we can, especially here in Missouri, we can even do a joint trust, because some people don't like splitting their assets up. I actually don't like splitting up assets in Missouri because it severs what's called tenants by the entirety protection, which is a lawsuit protection afforded to married couples here. And in a few other states, Florida's one, and there's a couple more. But so we could even do a joint trust where we clearly delineate in the schedules and the assets of the trust whose assets are who, and then we have a separate path for each of those pools.
But the tenancy by entirety problem only exists for the period of time until one of them dies.
Right.
So there is that period of time when there's a little loss of credit or protection is all we're saying. When you have assets in the name of husband and wife, Missouri, there's some credit or protection. And when you put certain assets in each of two trusts, for example, and if you do it immediately, like when you meet with your lawyer, so maybe you live another 10, 15, 20, 30 years, whatever it is, during that period of time, there wouldn't be that protection. But what would happen beyond that, of course, is your children and your grandchildren don't need it at that point, and nor would the survivor of you and your wife have it anyway, because obviously there's just one of you and not the couple. So there are other ways to protect assets. One thing we have failed to talk about, and we mentioned a moment ago, but I want to come back to it, is probate. I mean, a lot of people would have started this discussion talking about how many tens of thousands of dollars you save avoiding probate. I mean, that is often the way this subject of trust goes down, is people just want to talk about how much money you save avoiding probate. And it's true. I mean, in Missouri, you can look this up. You can look up, it would be if you type in the keywords of probate, court, administration fees. What other key words would bring up the
A
schedule?
personal representative's fee. That's I think the title of the section.
Yeah, so personal representative. Be sure and use that phrase. And you can look up and you can do the math, and you'll see that just having like $500,000. I hate to do any of this math in my head, but the point is, it would easily be well over $10,000 and maybe over $20,000. So it's not cheap. It's a lot of money, and the more you have, the more you pay. So some people on that alone, if we sit down with a new potential client and we start out saying, well, if we do this trust, you'll save, done.
Yeah, right.
Yeah.
So we wouldn't get to talking about all these marvelous things we've been talking about today. But I'm less interested in the fact that I think it's less valuable. Not that I I'm less interested in my clients not spending more of their money in court costs. It's true that I don't want to see you do that. But I think you should be far more excited about the possibilities that you can achieve with a trust the way we've just described it.
Yeah.
And going through probate court, doesn't that take a while?
It does. It takes at least 6 months. More likely, it'll be close to a year, maybe more.
As
Yeah.
a practical matter.
Yeah.
Just advertising is 6 months, right?
Yeah, that's the minimum that it has to stay open. That's just we open the estate, we publish it in the paper, we waited 6 months, there's no creditors. That's the minimum amount of time it can
And
be
that
open.
applies only to a will, correct?
Yeah, the probate estate.
Okay.
Well, we can publish a notice to creditors for a trust as well, and it'll shorten the statute of limitations from a year to 6 months. But yeah, specifically for probate, it's mandatory that it be published.
Okay.
It's optional for a
Yeah,
trust.
you might have, now that you've opened that door, you might have to explain a little bit. So what we're saying is normally, just to be clear, you do not have to probate a trust. So when you have a trust and somebody passes away, the trust just goes on. If the person who passed away was, for example, the trustee, the person who kind of makes decisions about managing the assets for the beneficiaries, that person would be replaced by the person you've named in your documents. You name somebody to come next in line. So you have a 1, 2, 3, and a 4, depending on if somebody passes away or whatever. So there would be a change in the trustee, but that happens, outside any court. No court's involved in that. And it goes on as it otherwise would. So the money can be literally distributed the next day. Literally the next day
Right.
from the death, from your or your spouse's death to your children, your loved ones. If that's the term of your trust, remember, you create the rules. So most of you, if you're listening to us, you're probably not handing out this money immediately after your death. You're probably keeping it available under conditions you've defined for your children and your loved ones. So they still get the benefit of it, but you've created something that protects it and gives them far more benefit than they would otherwise have.
Right. Yeah, the good way to think about it is if you're using a will as the vehicle to move your assets to the next generation, to your kids and so on, you have to ask at every step for this will to be administered. You have to ask, you present it to the court. Nothing's automatic, whereas a trust, the trustee succession is listed in there. It's more or less automatic. The assets passing from your name to now your children's names, more or less automatic. You've got to file some forms with the individual companies, but you never have to ask permission from a court. You don't have to get a bond or ask
Right.
a judge for permission to sell a house. Nothing like that. More or less, it's automatic.
And instead of having a relative as the trustee, you can also have a financial institution.
Absolutely.
How often is that done?
I wrote Fidelity into a trust before I came to this recording.
Okay.
So, it depends. It really. So if you've got children that you're worried about, and I've got a few clients that they're just, look, if I drop money, if I give this kid $1, he'll spend $2.
Yeah.
And so for that, they either name a relative, but then, the good thing about naming a relative is that they don't charge a fee normally. The bad thing about a relative is that their arm can be twisted.
Sure.
People like Fidelity or Edward Jones or all of the trust companies, they will go by the letter of the trust. They will go by the book and strictly enforce the terms of that trust. And if that's what you want, it's worth the fee to them to protect your children.
So what are we talking about? A fee, like a percentage of the trust?
It's typically structured it's like a tiered fee schedule normally based on the value of the asset. So a lower percentage for lower assets and so on.
Yeah, and it's not unusual. Like for those of you who, including insurance, life insurance and whatnot, you might have over $1 million. There are a number of places right now in the U.S. interest rates are pretty low, so you might pay less than 1%, or let's say 1% at $1 million. So there are places where you can get this money management and the benefits that come with it, being a trustee by an institution for 1%. And I'm telling you, I think that's a bargain. Even I would say 2% is a bargain. Just for me personally, if it were my money and I could turn it over to an organization that had professional management, remember, your brother-in-law Bill or whoever it might be, they may, even if they have the best of intentions, which they don't always, but even if they had the best of intentions, if they make a mistake and that money's gone, there's no recourse. They probably have no insurance for you to turn to for repayment of that. Whereas if there's some negligence involved by an institutional trustee, there's always recourse, meaning your loved ones will probably have a pocket to turn to with a lawyer's assistance to get repaid. And also you have just the professional management. Apart from the insurance, you just have professional management. And they're going to dot their I's and cross their T's, as you were saying, following the rules. I'm a big fan. I think to pay even 2% for that sort of peace of mind, I would be an advocate of. And it is very personal. But I know that my view as a minority, having talked to clients over the years, and I think that's probably I'm curious. Have you found that most clients just preferred an individual in the family versus an institution?
I have, yeah. It's definitely the minority of clients that choose an institutional trustee because of the fees. But in the end of the day, I mean, if you think about it, I always say it's probably 1 to 3% that you're going to get charged by a corporate trustee, where you're talking 4 to 10 just to get through probate. So it's definitely, I think you're right, it's worth it, but it depends on the value of the assets and the character of the children and things like that.
Well, I can tell you from personal experience, I think it is worth it because my husband, there was a family estate and his cousin was a trustee, and let's just say, not the most honest person, went on for years before she distributed any money. She didn't, provide any accounting and had to.
And you all felt there was nothing you could do.
Well, we did finally, and had a letter sent to her, and right away she distributed the funds when she was threatened with court action.
So maybe we ought to air this situation more fully on here. Get all the details relating to this.
Yeah.
But this sort of family drama, which incidentally probably would be interesting to hear.
Yeah.
But anyway, this sort of family drama plays out across America all the time. I mean, this is happening. I would say it's more common than not.
Yeah.
That you have, and maybe not overt dishonesty, but just making decisions that
no, she's dishonest.
Okay, but
she's a crook. Sorry.
I think you're wanting to tell this story, and I'm wanting to hear it, sort of, but I'm gonna resist. But I can tell you that even if it's a matter of, it's two brothers, for example, and one makes a decision where to placing the funds in a particular place or purpose, maybe they get some benefit from. I've seen where they'll hang on to a vacation home that it turns out that brother's still using and the other can't use, even though it's available to them. The fact is that one brother's in California, the other is here in Missouri and owns a property at Lake of the Ozark, and that Missouri brother is the one who's the trustee. So he decides to keep the property as an investment. And argues that it's fair, but it's not really fair. And there are better places to put the money. So those sorts of tensions, they come up a lot.
Yeah. And you bring up siblings. Siblings is a great point. I mean, because think of brothers and sisters fighting and brothers fighting, and then your parents die and one of them's in charge. I mean, they're going to fight.
Of course
and
they
it's
are.
their last chance to do it.
And throw in the spouse. It's often, now I don't want to defame spouses here, but I can tell you that sometimes it's actually the wives or the brothers, but let's just say the wives who are having, it's really they who are sort of ginning up to some extent conflict that shouldn't get there. If the husband, and I've seen this more than once, and I see it in the office when I'm sitting there. The client is the guy. More often than not, the guy would be my client, or at least he'd be his family. And so the wife there is sitting there, and he listens to her, whether he admits it or not. He's listening to what she's saying, and she's making the case of how he's being mistreated and how he's been treated unfairly. And he's sitting there nodding his head, and I can tell that these ideas did not originate with him. And so that I'm not hearing the voice of the wife that I know, of the other brother who I know that this wife dislikes and suspects is guilty of leading the other brother to be unfair to this brother. So these family dynamics, you really open a Pandora's box when you end up in probate. Now, you were, and this is good. We're circling back to a point that I wanted to have you address at least briefly. I mean, there are some advantages on a trust to sort of taking advantage at the death, or taking the opportunity at the death of the trustee or the trustor, we'll call it the grantor. When they die, that there are certain advantages for publicizing certain things in order to get protection. So maybe this brings us around to this point. So when we think about probate, we think about it as an occasion to fix things, but it also can serve as an occasion where you can provide insulation from creditors, et cetera.
Right. So because the trust doesn't go through probate, there's not a process for a creditor to really make a claim against a trust. They make the claim against the decedent's estate. And if we're not opening an estate because we don't have to, because everything's in the trust, then the creditor to legally make this valid claim and get it in front of a judge has to open an estate for this deceased person themselves as the creditor. So picture MasterCard going down to St. Louis County Court and filing paperwork to open an estate for, John Doe. It just doesn't happen very much. In fact, even if they make a claim against an estate that's been opened by the family, they don't show up for the hearing 90% of the time unless it's a big debt. So the trust is, because it's so private, we have the option to, like I said, publish a notice of the trust to creditors. All that does is shorten the statute of limitations they have to make a claim. But other than that, they're essentially just going to write the trustee a letter and say, "Hey, can you maybe throw us some money?"
But why do you do that if the trust doesn't have to necessarily pay those creditors?
So I mean, if it's a lien on other trust assets, so if there's a vehicle there,
or a house,
or a house, you'd want to pay those debts off, or at least figure out a way to transition them and continue to pay it, because you don't want to lose the trust asset.
Well, and you can't sell the house,
without paying the mortgage, right?
Well, I mean, if there's a lien on it,
right,
you're right,
yeah.
So there can be sort of maneuvers where you have debts that are owed by the person who died, and they essentially transferred all the assets, including perhaps assets that were directly or indirectly pledged into the trust. So in that case, if you have all the assets in the trust, then the person who just died, because they were doing good estate planning, they did not probate. Their family didn't probate a will because there's nothing to probate. There was nothing in their estate. It all was in the trust. So in that case, if you have a creditor, though, that has a claim, normally they'd submit that claim to a probate court during the probating of a will after someone's death. In this case, there isn't anybody who's opened that estate, because the people who have an interest in the assets know that it's in the trust and they're satisfied. So sometimes creditors will initiate actions, and they're allowed to for a while if they've been defrauded or they've had a claim that they didn't know about. So you're just making kind of it may be a little more sophisticated for the topic than what we would normally deal with. But if those of you who aren't interested at this point can ignore it, but some of you may be a little interested. And so there is a mechanism, as you just described, for going ahead and initiating, for the trustee to initiate something that starts a clock running. And then once that clock runs for a year, is it? Or less?
6 months with publication.
Okay, 6 months.
Yeah.
After that 6 months, guess what? Any claim that a creditor might have had, even for assets that went into the trust, they forfeited that. Now, if it's on real estate and they have a secured lien, that'd be an exception.
It's unsecured debts mostly, credit cards, medical bills. I see a lot. Mostly credit cards and medical bills.
Now, when you say publicize, where do you publish?
Paper in the county. We don't use you don't use the Post-Dispatch. You don't use a big. It's usually like Missouri Lawyers Weekly or a legal circulated publication in the county of death.
Now, what if someone has unpaid child support?
Unpaid child support. So it depends on the state, but some states do allow access to self-settled trusts, especially for alimony and child support. But as far as the trust is concerned, an inherited trust, if there's mandatory distributions of income out of that, then that would be counted in child support calculations. But I don't believe the assets are.
No. If this is probably a little bit of a complicated because this would be regarded as a priority claim in like a bankruptcy. So certain debts are treated in a very special way. IRS is one of them. So the IRS, generally gets their money, and their claim might survive that 6-month notice.
I think it might, yeah.
And so in many states, support claims are given this special treatment. But now it's actually been held unconstitutional for a support obligation to extend beyond the death of someone. So a number of collection agencies around the country have had their hands slapped for trying to effectively collect a claim on somebody after they had passed away. But that's for new obligation. If it accumulated before they passed away and it was a legitimate support order, then that's something that they might be able to get at. So there are a few concerns you want to have when you put assets in a trust. A trust, is not this steel vault that is immune to everything. And that's the reason that you have to have lawyers that you use when you do this sort of planning. You want to use lawyers so that they can anticipate the particular concerns you have. And if you had an IRS claim or expected to have a large IRS claim, then putting it in this trust is not going to provide asset protection.
No, and the good thing there's stages to these trusts as well. So if you set up a revocable trust and you are still alive, it's not providing you with any protection. And I always explain to clients this way, is that the underlying theme of asset protection is that if you have control or if you have access, then those can be used against you. And so if you put your money into this revocable trust and you try and say, oh, judge, there's no way I can pay this creditor because it's all in my trust, it's revocable. So the judge can tell you, okay, well, revoke your trust, take your money back and pay this judgment. And that's why after your death, it becomes irrevocable and the judge can't force your children's hands like that.
Well, what happens, because I do know of a real life situation where somebody, has been waiting for child support for several years, never got it, so she put a lien on this ex's house. Mm-hmm. Okay, so the lien's on the house. So what happens if he creates a trust and puts that house in there?
So the lien follows the house.
Sure.
Yeah.
So that means that
if that house is ever sold, it's just like a mortgage.
Okay.
Yeah.
So the house would not be protected necessarily by the trust.
No, especially if there was a lien prior to the transfer.
That's what okay.
Yeah. And just to point this out, though that's not been the purpose of today's show, we've done shows, I think, where we've talked about self-settled trusts that aspire to provide asset protection. And that means where you create a trust yourself, unlike the focus of this show, like Jim was just saying, where your goal when you go in and see your lawyer is you want to provide some asset protection for you during your lifetime. That's a different discussion. Can that be done? To a great extent, yes, it can be. There are some limitations, but for the most part, Missouri is very friendly to people whose goal is to provide asset protection for themselves in a trust they create. Again, don't confuse that with what this show's been about, which is providing for your loved ones when you pass away. And that's the one where it's fully revocable. You have full control. You do anything you want with it. But then when you pass away, then it becomes this irrevocable trust that provides asset protection. So as Jim said, if you have revocability and the sort of control that 90% of our clients want, you want to have control. You want to be able to reach in and change anything you want, and you want to. You like having the peace of mind knowing, look, if I decide to dump this whole thing, I can dump it. I've not done anything that I can't change, and that's true because it is revocable. That's the magic word. But if you come in and say, I'm worried that I'm engaged in a profession, I'm a lawyer, or I'm a physician who does a lot of procedures that carry risk with them. I'd like to have some asset protection for me and myself while I'm alive and my family. Then there are things you can do. You can create an irrevocable trust. And that's a more serious step because it limits you during your lifetime is how you use it. And we do have clients who do create irrevocable self-settled. Self-settled means you create it for yourself. Self-settled trust. We have clients who do that, but it's not every day because a lot of clients aren't prepared to live with the sort of rules and restrictions that they would need to live with if they want to be protected from someone suing them for, maybe it was negligence, not something intentional you do, but something that's negligent, like a tort, or just creditors. Or
Medicaid. I mean, we use the same type of trust for
Medicaid.
Protecting against lawsuit versus protecting for Medicaid. And I mean, just this morning I met with a client and he wasn't necessarily worried about being sued, but he had about $1 million sitting there that he wanted to make sure got to his kids. And he has a great pension. He lives comfortably off of his retirement and his pension and his savings, but he's got this $1 million that he just wanted protected. So he said, put it in your irrevocable trust. I don't care if I lose access to it. I don't need it. And so we set that up, and he was older. He was 70s, 80s, but wanted to make sure that money was protected for Medicaid.
Right, and so he was wanting to be able to get Medicaid coverage,
right,
and qualify for it, which means that he has to be broke in some sense of the word, right, to qualify for Medicaid. But you do because you really do limit, when you put the money in the irrevocable trust, the reason you can get asset protection or qualify for Medicaid is that in a meaningful way, you've limited your access and control. You've not completely eliminated it. It's not the same as if you had transferred it to a third party and you had no control or no influence or no benefit. You can get income from it. Mm-hmm. There are some things you can do. So I don't want to make this sound more painful than it is.
Yeah.
But it does mean you have to meaningfully give up some control, some decision making, some benefits in order to get these wonderful benefits.
Yep. Yeah, and things like the house are one of the main things we would transfer to an irrevocable trust like that. You can still live in it.
It's not like you're pushed out. Yeah.
You're allowed to live
to the
in
curb.
it.
Yeah. Yeah, trustee comes and evicts you day one.
Yeah, and or you can transfer that $1 million into an account and into an irrevocable trust. And if you're earning interest on that, which today's not so great, but let's say normal times, you'd easily earn $30,000, maybe 55%, $50,000 a year. You could take that $50,000 a year and that income, and still that didn't violate the fact that you have given up meaningful control of this $1 million. So you still get the $50,000. So it's not such a bad sacrifice. But that's the people who are not interested simply in saying, I want to provide all these wonderful benefits for my children and grandchildren, which is most of our clients want that. Or TuckerAllen's clients. But there is that minority of clients who, either because of Medicaid or for other reasons, will say, no, I want this asset protection and these benefits now for me. And then that's when you have to live with these restrictions.
Yep.
Wow, we've covered a lot of territory.
Yes, we have. You're always a wealth of information, Jim.
Yeah. It's kind of like the guy that knows all the pub trivia but never gets to use it. See, now I have a
venue,
Yes,
a vehicle to
go.
get my knowledge out.
Yeah.
Otherwise, it's just stuck in my head.
Well, one thing we should add to this show is we should add some sort of whiteboard. Or
That's a good
something like
idea.
that. I think that
Yeah.
would be helpful.
We could probably get one of those ones that even goes digital as we write on it. And
Now, is that in the budget, Justin? Yeah, I think we can allocate $19.95. That'd be your budget. But I've seen those boards. Those are really
the
cool.
smart boards?
Oh,
yeah.
It's all digital. It's
Yeah.
it's more like a TV screen or a monitor, a huge monitor,
Yep.
and you control it with your finger.
Yeah, they use them a lot on sports shows and stuff. When
Yeah.
they're-
Right,
they're,
right.
Like drawing football plays, and then they hit a button in the corner and it wipes it.
Be a great visual.
Yeah, we'll have to work on that, Justin. All right. Wow, we've gone 55 minutes. But you can tell this is a topic we believe in. I certainly believe in, but I know that Jim does as well because he deals with it every day. Don't let anybody simply do a will for you if you're in the position of the substantial majority of people. Don't think that trusts are for rich people. I mean, forget the tax issues. Trusts provide huge benefits.
Protection.
For anybody who has something that it represents 100% of what they've accumulated in their life. Whether it's big or small, it's 100% that we're talking about here, and it's for their loved ones. So this is a topic we'll come back to. Maybe we'll do a show in which we talk specifically about asset protection benefits that a trust can provide during your lifetime. We touched on it here at the end, but there's a lot more that can be said about it. But we don't spend a whole lot of time talking about it except in the context of Medicaid.
Right.
But it'd be interesting to spend some time talking about it, though, for people who are just business people or others who see that there's risk out there lurking in the world and they could be sued for so many things in America. I mean, this country, it's not going to become less litigious, I don't think, in the next 10 years.
I wouldn't think so, no.
Yeah, so
Not trending that direction.
No. And some people are willing to live with more restrictions in exchange for having peace of mind that their assets are protected. So there are some more opportunities there. Can you put that on the schedule? Talk
I
about that?
can, and we'll bring Jim back on. He's our go-to guy.
I'll be here.
Yeah, we'll do that in the next couple months. All right, good. Jim Gau joined us with TuckerAllen. Thank you.
No problem.
Another episode of ElderTalk. Till next time, take care.
You've been listening to ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of ElderTalk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.